fáiltíim raibh an deis píosa cainte dhéanamh maidir leis an mBille seo bille atá cuspóir ige córas cúitemh a chur ar bhain reachtaúil. Maidir le na cásanna carúla agus na cásanna sibhialta nuair atá máil míréasúnta i gceist. Agus tá sé tábhachta go rá nach bhfuil an dara ráha ag an rialtas ach an mBille seo a chur chun cín go pránach de bhár sra chásanna i gcoil siar níos mó ná 20 mbliain agus ón cuairt Eorpacha cearta an duine agus é ráite go soléir go bhfuil tepi ag an rialtas seo agus na rialtas hana raibh seo go raibh tepi umláin orthú córas a thuirteteach ó híomh muiledóireacht maidir le cásanna éagsúla. I welcome the opportunity to speak on this bill, a bill that has 6 parts and 37 sections, which provides for a new framework for statutory compensation for breach of the right to a hearing within a reasonable time in both civil and criminal matters. A pre-legislative scrutiny of the general scheme by the Joint Committee of Justice, and I want to thank them for their work and for highlighting the issues. It was published in May with 13 recommendations, and I might come back to those because it seems a substantial number of those were adopted completely by the government, and there was just one given a black, which is unusual, but I welcome the work, and I'm going to come back to those recommendations. Although the committee did say it was sceptical of the proposed non-courts model and remained to be persuaded that the non-courts model set out in the general scheme was the most efficient way of providing a remedy. Now, a regulatory impact assessment was also carried out and thankfully made public, because I've often spoken here and said the regulatory impact statement has not been made public. In this case it has. However, all of the costs have been redacted, and so one of the issues that was raised by the committee, whether the non-courts model was the better model or not, I can't make any decision on that because all of the comparable costs have been redacted. So I'm not sure, Minister, why that is. I went through it. It's a detailed regulatory impact analysis. I welcome that. But all of the costs have been redacted. So how can I judge, or any reasonable person on the ground judge, which model is the best? Although we're back to the patriarchal model, that you don't need to worry about that because we know best. And we've checked it and we've blocked out all the costs, but take our word on it. So I have a little difficulty with that. It's important too to point out the background of this bill, primarily drafted in response to a long line of cases decided by the European Court of Human Rights, which held that Ireland was in breach of Articles 6 and 13 of the European Convention on Human Rights. And Article 6 guarantees that hearings must be provided within a reasonable time. Article 13 provides for the right to an effective remedy. And we've utterly failed successive governments to ensure that the cases were held within a reasonable time and also to give a remedy when they weren't. It's also, I want to thank, as always, the Digest, the Library and Research for their very good digest in relation to this, and they've highlighted this for the TDs. Of course, we have protection under the Constitution, which is very similar to the Convention. Article 38(1) provides that no person shall be tried on any criminal charge save in due course of law. It does not expressly, however, protect the right to a speedy trial in criminal matters. However, the interpretation by the Supreme Court has always held and repeatedly held that the right to a speedy trial is protected by the guarantee of the right to trial in due course of law. Now, again, 38(1), while exclusively concerned with criminal trials, it is clear that the constitutional right to fair procedures outlined in 40.3 includes the right to have civil litigation heard within a reasonable time. The entitlement to a prompt decision is an aspect of constitutional justice. And indeed, the Supreme Court has characterised the right to an expeditious trial as distinct from, though overlapping with, the right to a fair trial. The focus of the bill is the rights guaranteed, as I said, by the Constitution and the European Convention of Human Rights. However, it must also be noted that the right of a suspect or an accused in criminal proceedings to be tried within a reasonable time is also guaranteed by a number of international human rights including the EU Charter on Fundamental Rights. On top of that, the bill also reflects recommendations made by 2 recently published reports, including the Judicial Working Group and the OECD report, and I acknowledge all of that. What's difficult for me, and it's been mentioned by other speakers, is the amount of time it has taken to stand up. McFarlane versus Ireland, the most significant of the long line of judgments, dated the 10th of September 2010. That was 2010, and I'm going to come to that judgment. But it has been over 20 years since the European Court of Human Rights first established that Ireland was in violation of the Convention due to the lack of an effective remedy for unreasonable delay. We're not talking about ordinary delay or delay that's caused by, that's reasonable. We're talking about unreasonable delay. And the McFarlane judgment, which was 2010, the implementation of that is currently under the supervision of the Committee of the Ministers of the Council of Europe. And they noted in September 22 that it remains a matter of profound concern, in September of last year, that the remedy has not yet been established. The McFarlane case has been pending before the committee for 12 years, and at that point, 19 years had passed since the problem was first identified by the European Court of Human Rights. Previous legislative initiatives had failed, and the authorities must act diligently and continue to give the necessary priority, and so on. This is what was said. Indeed, in the 2022 annual report of the Committee of Ministers, while acknowledging, like Deputy Callanan has done, while acknowledging certain positive development, nevertheless, they indicated profound dismay that an effective remedy for excessive length of proceedings had not been established. The government in March of this year submitted a revised action plan with particular emphasis on this bill. Now, it's also important to say that since McFarlane in September 2010, there have been 27 cases against Ireland in the European Court of Human Rights, of which 14 resulted in a settlement or a finding of a breach of rights. And indeed, notably, in April 17, 6 years ago, the court struck out the case of Blehin versus Ireland following a unilateral declaration by the government that there was no effective remedy under Irish law to deal with court delays. And this was incompatible with Article 13 of the Convention. That was 2017, Minister. And it has been argued, I know, by the government and other previous governments that there were remedies here in Ireland. And what the court said about that was current remedies for undue delay are either prohibitively difficult to obtain for a variety of reasons or are very unclear in their scope and operation. Therefore, a new framework must be implemented in Ireland to comply with its obligations under the European Convention on Human Rights. In Keeney versus Ireland 2020, the European Court of Human Rights noted that the scope of a damages action, the circumstances, and this was 2020, the scope of a damages action, the circumstances in which a complainant is likely to recover damages following delay, and questions of quantum all remain unclear and need of development through practice and case law. In O'Callaghan v. Ireland in 2021, the Supreme Court held that there were systemic deficiencies that were known to the state and had the effect of delaying the appeal in that case. They went on to give a declaration on damages, and they said delay can deny even a just judgment of its value. And I think this is of particularly interest, Minister. They went on to say there is a societal interest involved. If people believe that courts cannot vindicate their rights, then they will come to distrust the law itself and the system within which the rule of law operates. What is an issue is not simply an aspirational precept. It is a fundamental principle necessary for the upholding of the letter and the spirit of the law. The bill itself sets out the criteria and the primary objectives of the bill and what the assessors, the chief assessor and the other assessors need in terms of qualification. The chief assessor being a retired judge with a certain experience, and similarly for, not similarly for the ordinary assessors, they don't need to be a retired judge, but they need a certain time having practiced. And all of that set clearly, and I've no problem with any of that. My difficulty is the length of time it has taken to get this far, with the government arguing nearly every step of the way, notwithstanding that in 2017 they fully accepted that there was no remedy in Irish law, and here we are in 2023. I have a concern that there's a parallel system of justice now being set up with what appears to be a quango, and I keep an open mind on that. I would have liked to have seen the costing of it. The application is supposed to be dealt with within 6 months. I welcome that, because otherwise it wouldn't make sense to have further delay. I think it needs to be reviewed, Minister, every single year to see is it achieving its purpose and to see what the costs are. I just broaden it out by way of concluding comments, that it seems to me that we let our systems, whether it's the health system, whether it's the educational system that was mentioned already in terms of assessment of needs, the health system in providing a public health system, the law, we let it become absolutely dysfunctional. And then we're either forced by international, in this case the European Court of Human Rights, or other bodies to make changes. So if we look at the health system, and it's not a legal thing, but we let it become completely dysfunctional, and then we set up a national treatment purchase fund to deal with the dysfunctional system, and that in itself has become embedded in the system, which was supposed to be a temporary measure. In relation to direct provision, we have an obligation to carry out vulnerability assessments. I've no idea where we're on in that. From my own reading, we're failing miserably. In relation to education, there's an obligation to carry out needs assessment, and we already heard the TD from the rural group outlining the delays there. And then on top of that, I think just recently I heard an interview in relation to the Irish Penal Reform Trust, and their figures are truly staggering in relation to the amount of prisoners on remand without their cases being dealt with. And on the 26th of May, the report highlights worrying trends in the rising numbers of people in prison. 33% of prisoners on waiting lists to access that. They go on in relation to the situation in the prison, but the actual number of people on remand has risen, I would say exponentially, really, by the looks of it. In 2017, we had 584, and now 2022, we have 875. The average number of people being held on remand in Irish prison is growing. A 23% increase in the average number of people held on remand between 2021 and 2022, and so on, and a 50% increase since 2017, when this project by the Penal Trust was started. The data that we have indicates that people held on remand, they're spending longer and longer periods. Of the data published for 2019, there was an average of 31 people on remand for more than a year. This increased to 79, an increase of 154% in 2022. And the increase in seriousness of charges has previously been cited by the Prison Service as a reason for this increase. However, the Irish Penal Reform Trust say that further information is needed to interrogate this interpretation, and so on. They point out that remand detention can have severe psychological effects, with suicide rates higher among remand detainees than sentenced prisoners internationally, and that's from the Council of Europe. Research in Ireland has also shown that recorded self-harm rates are consistently higher for remand prisoners than for those charged. On every level, there's a need to put an end to the delays in processing cases, whether they're criminal or civil. And the fact that we now have to bring in a parallel system to put compensation on a statutory basis is an indictment of how we've underfunded the court system. This system should not be necessary. We shouldn't have a whole series of court cases from the European Court of Human Rights and a monitoring in place by the Committee of Ministers to ensure that we do the right thing. And indeed, going back to the previous Dáil, much time was wasted by a certain minister in relation to the court system who wasn't even in that brief, instead of analysing the problems of access to justice. And the access to justice has been repeatedly highlighted by the current Chief Justice and the former Chief Justice in relation to how unequal it is. And that's been the theme of their statements over and over, the access to justice and how we need to improve it. And indeed, the legal aid, I know it's under review at the moment, needs transformative change to ensure that people have access to justice with legal assistance. So I'll conclude by saying I welcome the bill, but I welcome it most reluctantly. I wish there was no need for the bill, and I wish at a certain point in the not too distant future we would be able to take this bill, when it's enacted, off the statute books, because we have sufficiently resourced our court system to make it what it should be.